Hi everyone, welcome to today's webinar on identifying and triaging domestic violence issues in community legal centres. Before we get started, I'd like to acknowledge the traditional owners of the land on which we are holding this webinar today. In Brisbane, they are the Turrbal and Yagara people. I wish to pay my respects to their elders past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd also like to pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening today. This series of webinars is part of a program provided by Community Legal Centres Queensland with funding provided by the Queensland State Government's Victim Services Funding Program, Building Capacity for 2018 to 2019. The program will include webinars, a written toolkit, and establishment of a peer mentoring network. We also have a legal disclaimer. This presentation and webinar is for professional development and education purposes for Community Legal Centre staff and is not intended to provide legal advice. It is not to be used for commercial purposes without the express permission of the author. Information is current as 16th of April 2019. Also, please take a look at our Keep Safe content warning on the bottom of the slide. Today, we're joined by Helen Wallace and Ros Williams from Caxton Legal Centre. Helen is the Senior Social Worker in Caxton's Seniors Legal and Advice and a Support Service, and Ros is a lawyer in Caxton's Human Rights and Civil Law Practice. They are very well placed to present this webinar to highlight the importance of identifying domestic violence issues and providing an appropriate response. I'll now hand over to Helen and Ros and talk to you again at the end of the session.
Good afternoon, I'm Ros Williams, a solicitor at Caxton.
And I'm Helen Wallace, Senior Social Worker at Caxton.
As you know, Caxton is Queensland's oldest community legal centre and our practice is focused on poverty law.
Right from the outset, Caxton has used a multidisciplinary approach to assist clients, and by this we mean that lawyers and social workers work together to assist people who experience multiple levels of disadvantage or need. In our experience, clients' needs are often their legal needs are often the least pressing of their many and often enmeshed problems. So the social work support we provide in addition to legal advice is critically important.
On our website, you'll find at no cost a very useful document explaining how our multidisciplinary program operates within one of our core programs, our Family and Elder Law program.
The document's shown at the link on the screen there.
We've been advised that the majority of you are CLC workers or volunteers in generalist services who are not actually working in the arena of domestic and family violence or family law, or at least if you are, that you only have basic experience in these fields. We're therefore today focusing on key areas of law and scenarios to keep on your radar where one might encounter embedded or hidden domestic family violence.
Also some client management skills or approaches for dealing with such cases, specifically from a social work perspective, and some important referral information. Our joint goal is for you to be better equipped to identify domestic and family violence when it's hidden under other issues and to more appropriately triage your assistance to your generalist service clients.
In our experience, domestic and family violence issues often appear in tenancy and homelessness matters, unfair dismissal and income support cases, debt and property recovery disputes, family law and estate disputes, particular criminal law matters, and elder abuse cases involving granny flat disputes and disputes about enduring powers of attorney, where there's a difficulty with the attorney. And we'll be referring to enduring powers of attorney as EPOAs.
So at the end of our 50-minute presentation, we'll recap and summarise our top tips for practice and try to answer some relevant questions.
Domestic and family violence covers a broad variety of behaviours, and Queensland's laws set out in the Domestic and Family Violence Protection Act 2012, as you know, cover a broad range of relationships. See in particular sections 7 to 20 of the Act. While most people usually will recognise overt domestic violence disputes between spouses and might call police to intervene, The general public may not always be aware that the Act also provides people who are being abused by, also covers people who are being abused by informal carers or other family members. Unfortunately, domestic and family violence can be easily overlooked when it takes a more subtle form, especially when it involves financial exploitation.
So just to get you thinking in advance, we'll get you to consider a case study. Please read the scenario on the screen now for a moment, and Ros will read it out loud as well. So have a think for a minute about what some of your responses might be.
A psychologist is providing grief and loss counselling to Maria and contacts the service. Maria is aged 83 and speaks Spanish, and the psychologist speaks Spanish. Maria's husband died 2 months ago and her son has moved into her house. He's taken over her finances, isolated her from the other family members, forced her to make him her attorney under an EPOA, and is now telling her that he is selling her house and placing her in a nursing home. Maria is distressed and confused. Her son is abusive towards her. He yells at her and handles her roughly. Maria is scared to talk to anyone about the situation. She doesn't want her son to get into trouble. The social worker confirms with the psychologist that Maria has consented to the referral and assesses the safest place to meet Maria is at the psychologist's office with a translator. The social worker discusses with the psychologist ways to keep Maria safe until the meeting.
So clearly there are various forms of family violence occurring here, specifically financial abuse, psychological abuse, emotional abuse, and physical abuse. You might already be thinking about the need to refer the client to a social worker for counselling and support, and possibly also asking how might it be possible to help this client with supported decision making. Consider the barriers that need to be overcome, such as language, cultural barriers or differences, the mother's advanced age, her poor understanding about our legal system, and importantly, her conflicted feelings and sense of shame or disbelief about what her son has done. You should always use qualified NAATI accredited interpreters in a situation like this.
Lawyers regularly impose best outcomes using a legal framework, but knowing what the client wants as the best outcome should guide your work for them. You might be thinking that the client should immediately revoke the EPOA and appoint a new attorney, lodge a caveat, apply for a domestic and family violence protection order with all the possible restrictions, and possibly obtain an ouster order to remove the abuser from the home. The public guardian, if notified about concerns, might even investigate misuse of the EPOA and take action in QCAT to have the attorney removed and a new guardian and administrator appointed. The client, however, might actually only want a bare protection order requiring her abusive son to desist from calling her names, and she might prefer to have family mediation organised as a way to try to re-engage her family.
You might be wondering if the client actually has capacity to provide instructions, and we've found this is where social work or other appropriate supports can make a huge difference.
A client provided with support may ultimately present quite differently and be shown to have capacity despite your initial concerns. They might just want to have the attorney redirected to do the right thing, and this might be possible through external guidance and proper education about the role of the attorney.
What is possible may well turn on other family support being activated for the client.
Turning now to preliminary indicators of the existence of domestic and family violence, here are some suggestions and recommended practices.
Just getting through the slides here. That's it. So if clients say you cannot contact them by phone, mail or email, highlight this on their intake sheet, and you can see our elder abuse service sheet on the screen.
Probe these instructions sensitively and always give advice about domestic and family violence where it's necessary.
Try to set up an alternative way of contacting the client, for example, via a trusted friend or a GP's office. When a client cannot name a trusted contact person, they're probably very socially isolated. So this will be the focus of additional referrals and your work with them.
And as we inevitably move, I think, towards paperless recording systems, take care to ensure that your service's electronic systems carry an alert about these contact risks and any necessary protocols for contacting the client.
It's really important for your reception or admin and volunteer staff, especially students, who may well be the first contact point with clients, to be properly trained to be sensitive to the signs of domestic and family violence and know to bring their concerns to your attention.
Train them to watch the interactions in the waiting room between clients and the people who accompany them. Also, equip staff and volunteers to know what to do when someone other than the client answers the phone when your service is calling them. Your people should not leave messages identifying themselves or why they're calling. It's also always worth checking if anyone else is listening in with your client. In our experience, this is something abusers commonly do, but the client might not disclose that to you unless you ask. When sending advice by email, we recommend sending the detailed advice discreetly in an attachment rather than in the body of the email itself, so that the content isn't immediately obvious to someone snooping through your client's emails. Now, as you know, financial exploitation within intimate relationships and families is a key form of domestic and family violence, although many such matters initially present as loan or debt or property disputes.
Be particularly vigilant if your older client attends with a difficult support person, carer, friend or attorney, and the issue relates to property or money. Develop a policy so that you can insist on conducting the preliminary part of any interview privately with your client to ascertain their wishes. You can exclude others from that interview.
If the client then insists on their chosen support person sitting in, well, of course, follow their instructions. In criminal matters, it's important for clients to be appropriately warned about any waiver of privilege that's going to occur when they let the third party sit in. You should manage the interview, and in our experience, it's important to respond firmly to any overbearing, belittling or belligerent behaviour by the support person, who will often try to talk over your client.
Use a social worker where you can to conduct a preliminary interview with upset or flustered older clients. The high stress they experience, especially when they become dependent on an abuser for some level of care, often interferes with their initial ability to provide clear instructions. Social workers usually establish rapport quickly and can explore what the client doesn't say as well, and support them to tell their story, negotiate solutions to urgent problems, such as finding access to alternative housing.
It really has been our experience that such support can be transformative as far as an assessment of capacity is concerned, and I've already mentioned that.
You could familiarise yourselves with the Queensland Advocacy Inc.'s manual about assessing capacity.
As you know, capacity is a legal test, but the level of capacity required in order for someone to make a decision varies depending upon the decision that needs to be made.
Where clients may have the onset of some element of dementia, try to assess how to optimise their capacity. What reduces their anxiety? A face-to-face appointment, meeting earlier in the day, or just after they've had their medication? Can they be in their favourite chair, in their favourite room? Once you're acting for a client and learn more about their situation, they may tell you that certain medication has adverse effects at certain times of the day, so arrange your appointments to suit them. As an EPOA, as you know, deals with appointing a substituted decision maker for personal matters, including certain healthcare decisions and or financial matters. Unfortunately, misuse of an EPOA is often the weapon of choice for many abusers and you need to take specific care when attorneys also attend at interviews.
Ensure your centre has a policy clarifying that the centre will not provide advice via third parties, and that when dealing with attorneys, the duly prepared EPOA must be cited. A copy of the EPOA should be retained on your file. Check the triggering clauses, especially where there are multiple attorneys. Check that they're operative. They may not have started to commence yet. Always check that the attorney understands their legal obligations, as well as the principles in Schedule 1 of the Powers of Attorney Act 1998 and the Guardianship and Administration Act 2000. The principles are mirrored in each of those schedules, and they must inform the substitute decision maker's decisions. Importantly, Principle 7, headed Maximum Protection, Minimal Limitations and Substituted Judgment, makes it very clear that the affected adult, that is the person who originally signed the EPOA, must be informed about and be involved in decisions affecting them. That is to the greatest extent reasonably possible.
Whenever couples present together for an interview, always take care to observe their body language and interactions, indicating if one of the parties is injured or frightened. You can watch out for signs of anxiety or overly flat affect.
Interviewing clients privately enables us to better ascertain if there is any power imbalance or any hidden family violence issues that should be addressed. Referring to our policy on point assists us to secure time alone with each client. Sometimes the accompanying person is very resistant to that, so it helps to refer to a policy. Importantly, we want to avoid doing anything that leads to any client later being conflicted out unnecessarily because we've seen both parties, or one party's sat in on the interview. Manage your conflict of interest processes with care. Sometimes the matter involves both parties and interviewing them together when their interests align is necessary. But always ask yourself, is it possible that the parties' interests might diverge at some later point? Be aware that a manipulative abuser may deliberately try to set up situations where the other party will be unable to get advice because they're conflicted out. We've encountered some fairly negative strategic conduct in this regard.
So we usually try to ensure that both parties can access advice from two different places, with us and with either a private solicitor or another CLC.
When a client discloses that they are experiencing domestic or family violence, refer them to police for help getting a protection order in place, especially in urgent cases. Your service might have capacity to help them with it, and in that case proceed, but if not, the police should help when it's necessary.
If you have social workers on staff, they can support clients to contact the police for help to obtain a protection order, especially in urgent situations. Or if your organisation doesn't have any in-house social workers, you can get acquainted with the other counselling and referral services that are available, such as counsellors through Lifeline, Centre Care, Relationships Australia, and of course DV Connect. Caxton doesn't provide a specialist standalone social work service or counselling service. Our counselling work's normally activated because clients present here with their legal problems, but clearly need other social work support, such as referrals for housing, etc. Currently we have 5 in-house social workers. Because many clients living in domestic situations of abuse are financially dependent upon their abuser, remember to refer clients for advice about Centrelink entitlements. Centrelink has in-house social workers, in most offices anyway, or via the phone, and Basic Rights, of course, provides advice on Centrelink disputes.
When a client discussing a general legal problem also mentions that there's some other DV proceedings on foot or that there's a protection order in place, check to see if they've had additional counselling, irrespective of whether they're victims or perpetrators of domestic violence. A non-judgmental conversation in this context, in my experience, can prompt the client to provide more relevant information to you. Where a client reveals that they're currently involved in proceedings, try to explain the relevant processes, give them Legal Aid's rather excellent guide on point, and tell them about available services including Caxton's, Pine River CLCs and Legal Aid Queensland's duty lawyer services. It seems appropriate at this point to tell you a little more about Caxton's Domestic Violence Duty Law Service, which exists to assist respondents and which is part of our overall family law service.
So the following slides contain information from Caxton's website explaining our family law and duty lawyer services. Specifically, note that we have duty lawyers who are available at the courts to help with family law and domestic violence matters at the Brisbane Magistrates Court, Domestic Violence Court.
I'll just summarise the slides. The service is available on all days the court lists cases. It's free of charge and doesn't require an appointment. The duty lawyer can provide legal advice and assistance with negotiations, including with police, drafting protection applications for respondents who've experienced domestic and family violence. And I'll just digress and say quite often it's the respondent who needs help. We can also provide help with related family law and tenancy matters, and we can give referrals to intervention programs. The service can also provide court representation for interim and procedural matters, but typically not for final hearings. Legal Aid Queensland duty lawyers provide advice to the aggrieved. To obtain assistance from a duty lawyer, clients should register with the court network staff outside the Domestic Violence Court on level 6 in the Magistrates Court building prior to the hearing. Now we turn to considering a range of general law matters where domestic or family violence may also be involved, although it may not be obvious at first glance. This summary is based on recurring scenarios encountered at Caxton's evening advice sessions, where volunteer lawyers without family law experience have nevertheless ended up identifying domestic and family violence issues requiring attention. Unfortunately, we don't have the time to unpack all the relevant law we'll cover, but we've listed and grouped under key headings the sorts of questions and issues that should act as alarm bells for you. Firstly, tenancy, housing and border disputes. Sometimes clients will be booked in for tenancy law advice because, for example, they want to urgently terminate their lease. They have concerns about insurance claims and their liability for damage to a rented property. They need access to their property being held by another co-tenant, or they're concerned about their liability for someone else's possessions left at their flat. They're homeless and need advice about their debts or fines, including spur debts. They want advice about removing a difficult border, or they're concerned about their entitlement to a bond refund.
Sometimes while probing the facts of such matters, it will become clear that the client's problems have been created by a violent co-resident, either an actual co-tenant or a domestic associate who was or is their partner. In such cases, don't just deal with the tenancy law issues. Advise about the domestic violence issues and or provide appropriate referrals, especially for social work support. We commend you to the Tenants Queensland fact sheet about tenancy and domestic violence, which you can find on the Tenants Queensland website.
It's important to understand that under Section 415 of the Residential Tenancies and Rooming Accommodation Act 2008, an order can be made in QCAT for an urgent termination order of a tenancy because of excessive hardship, damage or injury. Relevant sections of the Act include Section 310, which provides for applications for lease terminations for excessive hardship, and most importantly, Section 312, which provides for applications for termination for damage or injury. Section 344 allows QCAT to make orders because of damage or injury, and it lists domestic violence issues the court must consider. This covers intimate family and informal care relationships. QCAT can also order that a party be added to a lease and be recognised as a tenant, and sometimes that's the remedy that the vulnerable party needs.
If a client seeks advice about their potential personal liability for property damage to rental premises when the damage actually has been done by a co-tenant or housemate who's their current or former partner, you need to consider safety issues and whether or not the client needs immediate additional advice about a protection order.
Furthermore, it's worth noting here that if a complaint of willful damage to property under the Criminal Code has been appropriately reported to police, the court might order that restitution be made by the offender. If your client has concerns that they'll otherwise be liable under the lease to pay for damage to the rental premises, this option could be very important. Obviously, it would be preferable for the person who damaged the premises to have to pay the lessor compensation via a restitution order rather than have a victim of DV lose their bond or be otherwise liable for loss or damage.
When someone's been living in a situation of domestic violence, they may not have the self-confidence or energy to talk to the lessor, the real estate agent or the police about their partner's actions, and they may fear retaliation by their partner or eviction. This is when quality referrals, support to find alternative accommodation, legal advice about protection orders, and assistance with advocating with third parties can also be helpful.
And just note that even if your client did have insurance, unfortunately, a jointly owned contents property insurance policy might be void if one of the parties has damaged the property. So look out for those types of insurance inquiries as well.
You can find information about Queensland Police's approach to domestic violence on their website under Programs. If a client feels that their approach to police has been brushed aside, it is usually worthwhile speaking with the senior officer at the relevant station about the matter, and it can be very useful for a social worker or advocate to assist the client with these sorts of conversations with police. If your client wants to stay on in the relevant rental property but the violent spouse refuses to leave, it's important to remember that as part of making a domestic or family violence protection order, the court can also make an ouster order.
Sometimes one partner will have been taking money from the other spouse pretending they're paying the rent with it, and it may take some time before an innocent spouse learns of the rental arrears. Unfortunately, as you know, named co-tenants normally will be jointly and severally liable for the entire arrears. In giving advice about this type of tenancy issue, you should also consider referring the client for specific advice about domestic violence protections because, in certain contexts, this type of economic exploitation could fit within the ambit of the definition of domestic violence in Section 8(1)(c) of the Domestic Violence and Family Protection Act.
Referrals for financial counselling are particularly important when the client's own financial resources have been depleted by a controlling or abusive spouse. Information about how to find a financial counsellor is available on the Financial Counselling Australia website. Abuse that is hidden within housing or accommodation disputes doesn't just affect younger people. We've seen it in some older clients as well, who've taken on boarders in order to make ends meet, only to find that their boarder has become manipulative or controlling, and it's very difficult to get them removed from the property.
In an extreme situation, a scheming boarder may assert that they're actually in a de facto relationship with a homeowner, that family law therefore applies, and that they have a right to reside in the relevant residence. Unfortunately, in our experience, police are likely to hesitate to remove the boarder in such a case. If the relationship has indeed changed in nature and is some sort of de facto relationship, the homeowner could consider obtaining an ouster order under the Domestic and Family Violence Protection Act. I'm sorry, I think I mispronounced that before. That's what I meant, Domestic and Family Violence Protection Act. Furthermore, the Family Law Act does make provision for sole occupancy orders to be made, and this might be something that needs to be considered by the client. Referral to an expert family lawyer is recommended regarding this. If it's a true boarding situation, the boarder may over time have ended up being an informal carer for the owner, and this relationship can fall within the ambit of the domestic violence protection laws. If the boarder or informal carer is perpetrating domestic violence through economic abuse or exploitation or control, or is being psychologically abusive or controlling, the aggrieved can apply for a protection order.
The factual matrix becomes increasingly complex if the homeowner has the onset of dementia and the family get involved to try and resolve the problem. Sometimes a private relationship exists, but the client has not disclosed this to their family. If an older person comes to your centre seeking help to remove an unwanted boarder from their home, sensitivity may be required. An older client might be embarrassed about acknowledging their intimate personal relationship. Take care when interviewing and give the client ample opportunity to make revelations in a judgment-free environment. You could make a referral to our Seniors Legal and Support Service or the one closest to you, wherever the relevant client is over 60.
Otherwise, if a problematic individual is truly a mere boarder under a licence, your client simply needs to provide reasonable notice to leave in accordance with common law principles or in accordance with any written agreement. Turning to homelessness and housing issues, our Retirement Villages and Parks Assistant Solicitor has observed that one of the long-term consequences of domestic violence is that affected parties often end up with dramatically diminished finances and reduced accommodation options, especially in their later years. So they often end up living in insecure housing, including in manufactured home parks. In legal centres, you're likely to see clients needing advice about their rights in these manufactured home parks or rooming accommodation residences.
So where a client has never had any counselling or help in trying to deal with longer-term consequences of having lived through domestic and family violence, try to provide holistic advice and explore counselling options regarding the unresolved issues, even if the domestic and family violence was some time ago. And you'll be able to see our financial counselling referrals as well.
And homeless or other very vulnerable clients with complex SPUR issues should be referred to the complex cases team at SPUR because there are special arrangements that can be made for extremely vulnerable clients. Now turning to unfair dismissal and employment matters. Hopefully you're aware that Caxton runs a dedicated employment law service that includes our Wednesday evening volunteer appointments. We also have 2 employment lawyers on the ground during the day. Some of our clients who come to the service have sought advice about possible unfair dismissals and their entitlements where they've had their employment terminated for supposedly being too difficult or for taking too much leave. Upon probing the finer details of the relevant circumstances, we sometimes find that such descriptions are used to describe employees whose violent ex-partners cause trouble by repeatedly turning up at the workplace, or because a domestic violence victim needs to take additional time off work due to injuries, or to attend various court hearings, including family law hearings about children, or because they have to move residence to escape a violent ex, and so on. The law now provides for domestic violence leave, and it's unlawful for employees to treat vulnerable employees in this punitive way. Relevant details are contained in the National Employment Standards, which you can find on the Fair Work Ombudsman's website. And there are different standards depending on whether you're a state employee or national, but be aware of the national standards. Please note that employees are lawfully able to ask for flexible work hours. And if it's refused, employees need to give reasons. And so if you encounter someone in that situation, suggest they get detailed employment law advice. If a client experiences urgent financial need due to having to escape family violence, they may have prospects of obtaining early access to their superannuation due to hardship. Refer clients to a specialist employment lawyer and their super fund for more information.
Because of the risk of people reconciling with their violent ex-partners who then again exploit the vulnerable party's financial situation, these referrals should involve simultaneous referrals to good financial counsellors.
Now turning to various financial matters. When clients present for advice about joint debt matters, their liabilities under guarantees, problematic interfamily loans, tax debts, consequences of having been co-directors of family companies, problems with joint bank accounts, bankruptcies and failed businesses, you should always probe to see if there's been any causally linked domestic or family violence, including coercion or manipulation by a spouse or relative. Misrepresentation regarding the extent of financial risk and the amount of someone's exposure is common in abusive family relationships.
Here again, you could refer the client for appropriate financial counselling and for general counselling assistance.
Be aware that the Australian Bankers Association has produced clear guidelines recognising the impact of domestic violence in lending transactions. Further, AFCA will investigate where lenders failed to act on the warning signs of domestic violence and where the customer will not benefit from the funds advanced. AFCA will expect the lender to rectify the situation, for example, by waiving the debt or making other appropriate arrangements. Our consumer lawyers assert that the best outcomes occur when a legal centre advocates with the lender on behalf of the client. I should note that the ABA and the AFCA guidelines confirm that it is not appropriate for a creditor who is aware that a person is experiencing domestic or family violence to list a default on the person's credit report. Complaints about credit reporting can be made to the Office of the Information Commissioner or to AFCA. In the context of financial abuse and exploitation, we've seen many granny flat arrangements that have gone badly wrong. Most importantly, where a client invests in the building of the granny flat, clearly the client should go on the deed as a registered co-owner, and the agreement needs to be carefully documented.
Where you encounter a granny flat or loan case that's gone wrong, please be aware of how difficult it is for the older clients when a family member betrays them in this way. Referral to a seniors legal and support service is very apt in such cases. For our older clients, the sense of shame and embarrassment about what has happened will often cause them to underreport the abuse and exploitation they've experienced. A multidisciplinary response is preferable in such cases. And again, always use proper NAATI accredited interpreters for cases involving people from culturally and linguistically diverse backgrounds. Probing their cultural mores can be challenging, and you might need to remember that what might seem like abuse in Australia may be considered quite straightforward in someone's country of origin.
And that's why we referred earlier to education and negotiation, because sometimes that can get a better outcome than going in or guns blazing. For an important case illustrating elder abuse involving loans, I refer you to read the 2017 Queensland Court of Appeal case of Bergen and Bergen. That's Berghan and Bergen at page 236. It is a highly relevant example of how financial abuse gets out of control in family situations, and in fact the facts are quite startling. The next issue we wanted to flag was Centrelink. So it's well known that fraud and misappropriation are the major reasons why women in Queensland end up in jail. And obviously this includes Centrelink fraud. Sadly, relevant offences sometimes occur due to domestic and family violence factors. So if you're advising a female client about criminal processes and Centrelink fraud, keep this in mind, as the client may also need counselling and support about domestic and family violence issues that have affected them. And of course, this can happen for men as well in same-sex couples, or sometimes the woman might be the perpetrator, but more typically we find that the women are the more vulnerable parties. These issues may also be relevant in a plea. It could be addressed in a counsellor's detailed pre-sentence report. Hospital records may also need to be obtained, highlighting the relevant evidence of any domestic and family violence in a person's history. And that's not something you can just do overnight. Time is required to get those records.
If your client's escaping from a domestic violence situation, they should speak with Centrelink about their changed circumstances immediately, and they may be eligible for crisis payments.
Now turning to other criminal issues. Be mindful that where a client presents seeking advice about outstanding warrants or drug possession charges where they've taken the rap for a partner, or it may relate to traffic fines where they've acknowledged that they were driving the car when they weren't, and they disclose these matters arose during a time that they're in a violent relationship. It may well be that their underlying issues have not been resolved unless the client has been through extensive counselling or other therapy.
So again, you could consider social work referrals.
If a client needs to hand themselves in to be dealt with by the court, make sure that the client knows to attend at the watch house at an appropriate time and on an appropriate day. It's best not to go in late on a Friday or on a Saturday. Earlier in the week and earlier in the day is better. Sometimes someone's criminal record can end up having unforeseen consequences. So, for example, if someone is trying to get a blue card, an old offence relating to a period when the client was living through domestic violence can be particularly problematic, especially when it resulted in a child welfare department report and the department becoming involved because a parent has failed to leave a violent relationship and protect their children. The issuers of blue cards tend to take a very conservative approach where there are such matters on record. The client can try to appeal a rejection, of course, but it's preferable for a client making an application for a blue card to place quality evidence before the decision maker up front. Social workers may be able to provide a useful report supporting the client, and just be aware that there are appeal time limits.
Our clients will sometimes raise complaints about police, and we have an important role in acting as advocates for clients who've had difficulties dealing with the Queensland Police Service.
For example, if the police are called to a situation where one party speaks perfect English but the other party does not communicate effectively in English, or they're deaf and they're signing, the police may end up only listening to the person who can communicate easily with them and clearly, and they may even misconstrue your client's actions towards them. This is where a CLC can help write submissions to the QPS on behalf of the client. Next issue I wanted to talk about is privacy. We've noticed that people are increasingly worried about breaches of privacy, especially a breach by a bank or government department. So be mindful that your client's privacy concerns may be because they're on the run from a violent ex-partner. Where a bank mishandles information giving out a client's details to an ex-partner, your client could consider a claim for breach of contract, notifying the Australian Information Commissioner's Office, or they might make a complaint to AFCA. AFCA can award compensation of up to $5,000 for such a breach, and the Office of the Information Commissioner theoretically can award much larger amounts and has done so, and we've seen some matters up to $20,000 and some of course are much less.
A client attending for advice about being stalked or defamed on social media is likely to benefit from some social work support as well. These types of issues are increasingly being raised at Caxton.
It's worth noting that in a stalking case, the judge can issue a restraining order under Section 359F of the Criminal Code, and the section states that that can be done even if a person is found not guilty of stalking, so that's worth keeping in mind as well. Next, our coronial program. As many of you may know, Caxton commenced its coronial assistance legal service early last year. One aspect of this practice that intersects with domestic and family violence, which is not necessarily obvious at first glance, pertains to family disputes about decisions relating to burial and ownership of ashes. Where there are strongly conflicting interfamily views about where someone should be buried or who should have the final say in the interring of ashes, etc., it's worth remembering that such family conflict can, in our experience, be the result of people having lived through serious domestic violence at some earlier time of their lives.
So be alert to these issues. It allows you to know when and how to provide additional referrals for counselling, such as grief counselling or family therapy. You can also consider referring clients and other family members to a good mediation service.
The next topic is property and family law, children's matters.
So clearly domestic violence can colour all other aspects of family law advice, but here are a few of the related matters specifically worth mentioning.
Abusers don't just control a spouse. They often like to control their children because that's a way of controlling the spouse. So accordingly, if a client wishes to travel overseas with a child or their children, but the other parent without good reason won't sign the relevant child's passport application, or they refuse to consent to the child or children travelling outside of Australia, the court can sign the application and approve the trip. And the court can consider these matters urgently in appropriate cases. Where a client rightly is worried that a child may be removed overseas without permission, you should refer them to a family lawyer for urgent advice about what is known as a PACE alert. The overlap between family law and general law can be confusing, where parties were in a short de facto relationship under 2 years that doesn't trigger the operation of family law property protections, unless, of course, there was a child of the relationship. A client will sometimes describe a matter as a debt case, but there may still be arguments that the dispute should be dealt with under the Family Law Act if the dispute involves a significant financial contribution made during the relationship, and a declaration on point can be made. At this point, it's worth noting that you will sometimes see a client not covered by the Family Law Act who needs advice about property settlement, about property that has been left with them in circumstances whereby they've become an involuntary bailee. And it might surprise you, but we regularly advise on such matters and don't assume anything in this when these scenarios arise. And check how urgent the matters are. The other party may deliberately have left your client with unwanted property as a way of causing problems for your client. You should consider practical solutions, but ensure that your client understands their duties as an involuntary bailee. Don't tell your client to take action that could expose them to a claim of trespass to chattels, detenue or conversion.
Refusal to acknowledge paternity, non-payment of child support or school fees, or insisting that child support be paid as an in-kind payment for particular things can all be indicators of controlling behaviour. When clients are struggling to cope with such issues, you could again suggest social work support.
Another issue to bear in mind relates to personal injury claims. Make sure that you advise domestic and family violence clients about personal injury time limits if they have a potential personal injuries claim for civil assault that occurred in a domestic or family violence context. Also, be aware that domestic violence victims who have been injured are eligible to apply to Victim Assist for a special assistance compensation payment, which I understand, after looking last night, can be $10,000. Court processes are also important in this general discussion, and clients who are involved in legal proceedings against a violent or abusive spouse or other party will normally be highly stressed about court processes. It's therefore very important that we advise clients that all the courts have special processes for protecting vulnerable witnesses. Concerns can be raised directly with the court during proceedings, and be aware that there are some new processes for cross-examination where domestic violence exists, but as I understand it commenced in September. We have another case study to discuss, but we might just jump ahead for a moment in the interests of time. Turning to social work strategies and top tips.
Okay, so we've got a list of important referral points that are included later, but a number of suggestions for social work responses in this case, which are summarised on the slide. So I'll just run through these quickly. So always consider safety planning as a priority. Remember to give clients the opportunity to speak to you alone without a support person, at least initially. Don't use a support person as an interpreter. Use accredited interpreters and signers. Remember that your listening and observation skills are invaluable in establishing that relationship with the client where they'll be able to trust you. Understand that a client experiencing stress and hardship will struggle to act on your advice just because of the overwhelming emotional state that they're in. Build some solid partnerships with your local community services if you haven't already, and if you don't have an in-house social worker. Make a priority of building those links with your local homelessness and housing services especially. Support your clients rather than dictate the outcomes. If they seem reluctant to take action, pause, give them time and ask them about that. Stay alert to family dynamics. Don't assume a dementia diagnosis means that capacity has been lost. Recognise that dementia can progress slowly. Remember, your client's a person, not a diagnosis. If you can do home visits or meet in settings where the client is comfortable, this is very important, especially for frailer and older clients. Help your clients with the practical legwork when they can't do it alone, even if it does take a bit of time, so that you do get an outcome. And of course, many of our clients have low literacy skills. I've mentioned emergency housing options, and if in doubt, consider a social work or support service referral. And some of the top tips for referrals are there on the screen: DV Connect, Women's Line and Men's Line, Sexual Assault Helpline, Elder Abuse Prevention Helpline, that is a statewide one, Lifeline Crisis Counselling, the Suicide Callback Service, Kids Helpline, Financial Counselling Australia National Debt Hotline, and Homeless Hotline.
So in summary, the main takeaways from today can fairly be summarised as follows. 1, always speak with clients alone when they first attend with a support person who's a family member, carer or concerned friend, and similarly always use qualified interpreters to get instructions when interpreters are necessary. Secondly, look out for alerts about a client's vulnerable living circumstances and use your social workers for referrals to support networks and services. 3, keep this list of other legal issues in mind, ones we've run through today, so that you're aware that domestic and family violence issues will often overlap with these general issues.
And when you're dealing with an older person who's vulnerable to elder abuse, try to use a multidisciplinary model whereby you have social workers help with the intake and support, or make some referrals to supplement your own legal work. We're almost at the end of the time, but there are a couple of questions that have come in before the session.
I'll deal with one. One is, why is there so little education of about family violence in primary and secondary schools? That's from Gary in Mount Isa. I've actually discussed this with a high school teacher, and his view is that schools regard domestic violence as adult business, and they focus on anti-bullying campaigns because they think learning about inappropriate behaviour in the bullying context then informs people's views about respectful behaviour. As a result of the Not Now, Not Ever report, there were a number of recommendations which included school principals taking a lead on trying to eliminate domestic and family violence. So I think over time this might change, and at the moment what's happening in schools is there's a focus on respectful relationships. But stay tuned, I suspect things will change.
Paul asked, we have more financial and controlling behaviour abuse. How can DVOs be brought successfully and breaches reported? So I know I've had clients, social work clients with a lawyer, and we have successfully had protection orders put in place for that financial and controlling behaviour. I think the behaviours were still explained quite explicitly so that the magistrate got a clear picture of what was going on in the household. And there's the vulnerable persons unit within QPS. If you feel that a client's reporting breaches and there just isn't any real follow-up from it, I'd have a talk to the people in that vulnerable persons unit in Queensland Police.
And the final question we were given related to...
Sorry, we just had a follow-up question on how the police can follow up. I'm not sure that's really your area.
People can make a complaint to the police, and my experience has been that it depends on the officer you speak with. If they've been poorly trained about these issues, they'll sometimes be dismissive, and I guess it also turns on how much of the work they've got at the moment. But I think it's always worth following up in writing and sending your letter of concern to the team leader or the senior police officer in charge of the station and CC a copy into head office, because I think that police are increasingly understanding, especially in elder law violence, that financial abuse is a huge problem. So it's important to persevere, I think. The final question we had that had come in earlier related to cross-examination of vulnerable witnesses. I just noticed last night in looking at the newsletter from the Family Law Pathworks Network that there's a page on the Family Law Act amendments that came in, which commenced on the 11th of March, talking about amendments to cross-examination of people who've been victims of domestic violence. So perhaps have a look at that amending act. We are actually out of time. We had a scenario that we developed, which is, I think, on slide 37. Perhaps for reflection, read that, and then we've put some of our top tips that we'd be considering in relation to that scenario. I'll just hand back to Amanda for a moment.
Thank you everyone for attending, and a really big thank you to Helen and Ros for so many great practical tips and giving us so much information on how to help clients. A recording of this presentation and the PowerPoint will be available online. Thanks.
Thanks everyone.